fully considered by the trial court. The evidence in the record shows that my client asked for a courtesy stop in this case. That is a discretionary stop other than a normal bus stop. The evidence in the record shows that this courtesy stop was at the intersection of 6th and Market in Chattanooga. The record shows she requested that stop multiple times. For whatever reason, that stop didn't happen. It was passed. Well, when the bus stopped, my client asked, I need the intersection, not the bus stop. Is this the signal light? She said. Again, she asked, is this the signal light? I need to get off at the intersection of 6th and Market. The record shows she was confused. She didn't know where she was. She said, is this the signal light? And the bus driver responded, the traffic light is right there, which is an interesting statement to make to an admittedly known blind person. She said, I'm sorry, I don't see, and she was discarded from the bus. No effort to assist her. The crucial fact in this case is, I think, two things. One is misconstruing the nature of the negligence. And although the issue here is causation, the nature of the negligence affects the analysis on causation. The trial court concluded that the negligence in this case was the failure to put Ms. Roberts off at the requested stop. And I would posit to this court, as I posited to the trial court, that that is not the negligence. That precipitated the negligence. The negligence was in putting a known blind person off of the bus when she clearly, visibly, and undisputably was confused and dazed. That is the negligence, and that affects the analysis.
What was the bus driver to do then at that point? Keep her on the bus or what?
Well, Your Honor, the record shows that, and I'll get to this in a little bit, but with regard to the duty and what the driver should have done, which isn't an issue that the trial court decided, but what the drivers had done in the past, and in fact what Ms. Roberts had grown accustomed to, was that if her courtesy stop had been passed, she was accustomed to the drivers seeking permission from their supervisor to go back and drop her off at that location. That's
Did she make such a request?
She didn't know where she was, Your Honor, at the time that she was put off the bus. She still didn't know where she was. In fact, the record shows when she got off the bus, she started to walk forward, which is what the record shows she would have done if she'd been put off at her normal stop, and her guide dog stopped her. And she realized why, because there was a wall there. And that's when she knew for sure she had no idea where she was. So that's why I would suggest to the court, that's why she wouldn't have asked for that special accommodation.
And she's been trained, I understand, on both stops. Is that correct?
That is correct, Your Honor. However, there is a significant fact that I think the trial court failed to consider, and that is the degree of the training. The evidence in the record, Ms. Roberts' testimony was that she had gotten off at this particular, she had used that particular stop, the one that she was put off on the date of incident, July of 2020, once or twice. She had been extensively trained at her courtesy stop, which was the intersection of 6th and Market. And that makes sense. Even the few times that this had occurred, that she had passed up her courtesy stop, the usual order of, the usual procedure was that the bus driver would be made aware of that and would take her back, would get permission from the supervisor and take her back to her stop. Wouldn't force her off the bus at a location where she has no idea where she is. But the record shows that's what happened here.
Was there any testimony or was there anything in the record that shows that there was actually danger at this situation, at this stop?
There is nothing in the record to show that there was anything peculiar about this particular stop that would make it any more dangerous than another stop inherently. And the trial court certainly put a lot of weight into that fact. But, Your Honors, what that fails to consider is, in a vacuum, there's no distinction between the stops. But for a blind person who is extensively trained on stop A, not extensively trained on stop B, and who is confused as to her location and dazed and doesn't know where to go, that makes what for any normal person might be a perfectly safe location a very unsafe location. I used probably a terrible example in my brief of, a blind person may intellectually know I'm at the top of the Empire State Building. Doesn't mean they know how to get down. Maybe, I know I'm in the middle of the woods. Doesn't mean that I know how to get out. And that's exactly what we have here. She didn't know where she was. The trial court did put...
I'm sorry, go ahead, finish.
The trial court did put a lot of weight into the fact that my client ascertained her location. That is, on some level, eventually, after she got off the bus, became aware of her general location.
And that was a specific finding of the trial court, that she ascertained her location after she got off the bus and realized she needed to cross 6th Street.
Yes, Your Honor.
So, so at that time, she knew where she was.
Well, I would say, Your Honor, the record shows...
By the trial court's finding.
Yes, Your Honor. Yes, Your Honor. And 2 points on that. First of all, the testimony in the record was, quote, I kind of got my bearings. And the evidence in the record shows that she did have to ask a passerby for directions. It's not clear what directions she got. But even if she became intellectually aware of her location, for a blind person who relies on muscle memory and being trained to navigate certain surroundings, that's only half the equation. And I think the trial court failed to consider that as a blind person, just because, I know that I'm here, it doesn't mean that it is now inherently safe.
Help me here, because it was difficult for me to figure out. Once she got off the bus, where did she go? Did she go back towards where the courtesy stop was? I mean, it was for me difficult to tell. I'm not familiar with Chattanooga, so they talk about streets and...
Yes, Your Honor. So initially what she did when she got off is she started to walk straight away from the bus, which is exactly what she would have done if she had been let off at the intersection at her courtesy stop. She started to walk straight, encountered a wall after her guide dog caused her to stop. She asked for directions. At some point, she decides she's going to turn to cross 6th Street to get back to across the intersection to where she would have been had she been let off at her courtesy stop. And in turning to step off that curb to cross 6th Street, that's where she fell and broke her ankle.
Did a bystander provide those directions?
It's not explicit in the record, but what the record establishes is that she did ask for directions and then became intellectually aware, okay, I need to go this way to cross 6th Street to get back to where I was.
No evidence that it was provided by the bus driver?
No, Your Honor. No, Your Honor. So
where's his duty at then? Once she's actually off the bus and she is heading toward her destination and getting advice or direction from someone else, and even directions basically from her guide dog. So where's his duty at? Where does it stop, and how far does his duty continue?
yes, Your Honor. I would note first that the trial court decided this case exclusively on the causation issue, and explicitly did not decide the case based on whether and to the extent a duty existed. However, I would note that there is a heightened duty for common carriers, and certainly in the case of a person who is visually impaired, who is disabled, the argument there would be that there is a heightened duty for that person. The case law, and specifically the case of White v. City of Gatlinburg, a federal case, but it does speak to this issue, noted in that case where certain persons had been let off the bus and had walked away out of the view and control of the bus driver and became injured, that was too far. The court in that case noted that the only time that thus far the duty has been extended beyond the doors of the bus is in the case of school children, where they're let off the school bus, they have to be protected within a certain line of sight. I would note, however, that even in that case, the court noted that the common carrier has a duty to put the passenger off in a safe location. And I would propose to this court that by putting a visibly and admittedly blind person off of the bus when they are admittedly and clearly confused as to where they are, and the witnesses in this case in the record admitted that it was reasonable and foreseeable that such a person might become injured if they don't know where they are, that was a breach of their duty as a common carrier. So, Your Honors, I think that the trial court critically failed to consider the difference in this case that is made by the fact that my client is blind. There's no difference between the locations that might otherwise affect this case if we weren't talking about a blind person. But for the defendant to put off a known blind person when she is absolutely, unquestionably confused and dazed is negligence. And a reasonable trier of fact could conclude, although this one didn't, a reasonable trier of fact could conclude that this was negligence and that the fall that resulted still close to where she was put off was a reasonably foreseeable result. And for that reason, Your Honors, we request respectfully that you reverse the lower court's decision granting defendant's motion for summary judgment and get this issue back to the trial court for a decision on the merits.
All right,
Thank you.
one more.
Yes, Your Honor.
The trial court found, and this was summary judgment, right?
Yes, Your Honor.
I guess trial court found there was no dispute that she fell when she stepped off a curb.
Yes, Your Honor.
No dispute that she knew there was a curb there when she stepped off.
I think the evidence in the record was that she was looking for the curb. Certainly, I don't think there's anything to indicate she wasn't intellectually aware that that bus stop had a curb between the sidewalk and the road.
The trial court found, at least according to the trial court's order, that there was no dispute that she was aware a curb existed.
Yes, Your Honor.
Okay.
But for a blind person to be aware something exists and being able to find it are two entirely different things.
Okay.
Thank you, Your Honors.
Thank you. You have your time for rebuttal.
Thank you.
Here from the appellee.
May it please the court. Good morning, Your Honors. My name is Aaron Wells. I am from Chattanooga, and I represent CARTA in this case. I do have a few things that I would like to address, but I primarily would like to answer any questions that the court may have. The first thing that I would like to address, and Judge McClarity, you asked about it already, is the duty element. And the trial court did not specifically reach this issue, but we did brief it, and so I'll touch on it shortly here. We submit that CARTA's duty to Ms. Roberts extinguished once she got off the bus. And that position is supported by the Gatlinburg case that Mr. Hargraves mentioned. And while it's not binding on this court, it's a case from the U.S. District Court from the Eastern District of Tennessee. It involves some analogous facts, and it's instructive in this case. In that case, what happened was some passengers on a trolley specifically requested to the trolley driver that they be let off. It's at the bottom of the hill or the bottom of some stairs where a parking lot was, and the trolley stop was actually located at the top of this hill. Bus driver said, "No, I'm not letting you off there. I'm going to let you off at the regular marked stop." These folks got off and a couple of them ended up tripping and falling on their way down that hill. And in that case, the U.S. District Court found that essentially the holding is that a common carrier's duty doesn't require the carrier to ensure a person's safety all the way to their final destination after they exit a vehicle. And I think that speaks to your question, Judge McClarity, is when does this duty end? Because these are incidents that could happen to anyone despite any sort of impairment. So I guess the question is, when does the duty end when someone gets off the bus? I'll talk about it here in a little bit, but the root of our argument is that this is an incident that could have happened at any time during Ms. Roberts' journey from a bus stop to the Y where she was headed, no matter where she was let off the bus. And that's just by nature of her visual impairment.
From what the undisputed evidence presented to the trial court was she familiar with the curb where she fell? Was she familiar at all with that curb? And I know it may sound odd, but was she familiar with walking off that curb?
This specific curb, I think the evidence is that she felt for the curb just before she she stepped off of it, indicating that she was aware that it was present there. There is evidence in the record that Miss Roberts was an independent person. She, despite
I
her visual
understand. My
impairment.
question was, though, had she used this curb, this step before?
I believe that, I don't know that evidence is directly in the record.
That's
but-
all we can look at.
Sure. The evidence would be that at the time she felt for the curb,
That's what the trial
indicating
court.
a general
yeah,
awareness that it
trial
was
court
there.
found that she was aware of the curb.
Yes, and I think, I believe that's correct.
Okay.
She had been trained on this route specifically at this marked stop between 6th and 7th Street, and she had been trained on that courtesy stop location as well. But going back to duty, we submit that the duty was extinguished once Ms. Roberts got off of the bus at that safe marked stop between 6th and 7th Street, which is about a half a block away from the stop that the courtesy stop she requested.
Excuse me for interrupting, counsel. Were there different levels of training with respect to the two stops, the courtesy stop and the regular stop?
I believe Mr. Hargraves was correct of his resuscitation of the facts. I believe she did have more training at that courtesy stop location than she did at this marked stop between 6th and 7th Street. But there is evidence of record that she had extensive training otherwise, riding CARTA transportation and just navigating downtown Chattanooga by herself as a visually impaired person. So yeah, she was an experienced CARTA rider, and she's experienced getting around downtown on her own.
Is the training provided by CARTA?
That's correct, yes, sir. It is called a rider trainer, and they just ride with folks and get them familiar with a given route, and that's what Ms. Roberts did. Second issue I'd like to address is causation, which is what the trial court decided this case on. And the bottom line to our argument is there's nothing that CARTA did or did not do that caused Ms. Roberts' injuries. And that argument is rooted in a couple undisputed facts that I'd like to point out to this court. And the first of which is, and we've already talked about it a little bit, is Ms. Roberts was an independent person. She testified before this incident. She would go around downtown Chattanooga once or twice a week and walk around by herself with she and her service dog. Likewise, and again, we've talked about it, she had extensive experience riding CARTA buses. I will say these are under different circumstances. This incident, her boarding and exiting the video was captured on video, and during this period of time was right in the middle of COVID, so they did have some protocols in place, one of those being that the front half of the bus was blocked off. So she could not enter through the first set of doors like she was accustomed to. And she was accustomed to also sitting right behind the driver, essentially, sort of catty corner to him or her. And she couldn't do that in this case. She entered through the middle doors. She sat in what she thought at the time were the seats directly behind the driver. And when she got on and initially requested a courtesy stop, she was actually talking to another passenger that was sitting to her front and to the left. It was not the driver. Which leads into the next point. Communication could have been better. We're not hiding from that. The bus driver could have done a better job communicating with Ms. Roberts. When it became apparent before she was exiting the bus that she was somewhat confused about where she was. But I disagree with the characterization that CARTA put her off the bus. Like I said, there's video of this incident of her exiting the bus, and it is somewhat chaotic. There's passengers coming in, there's passengers coming out, and a couple of the passengers are actually pretty rude to her, trying to get her to get out of the way. So I don't agree with the characterization that CARTA put her off the bus at this location. But nonetheless, despite these communication issues, CARTA also utilized a system called Clever, which is an automated system that goes out over the intercom of the bus that calls out major intersections and calls out all marked CARTA stops. So there were other means for Ms. Roberts to discern her location, and there's no evidence that wasn't working or that Ms. Roberts didn't hear those announcements or anything like that. And next, and perhaps, well, before I get there, the stop, the Mark Carta stop. There is absolutely no evidence in the record that that stop was any less safe than the courtesy stop that she requested. There's nothing about the curbs, nothing about the sidewalks, or that it was just generally more dangerous than the courtesy stop location. Nothing like that is in the record. And then perhaps most importantly, it's undisputed that after Ms. Roberts got off to the bus, she figured out where she was. The testimony was that she got her bearings. She asked someone to point her in the direction of 6th Street, and she did. She started walking towards 6th Street, and she got at the intersection and stood there and waited. She testified that what she normally does is she waits on the light, and it would have been on Market Street, to turn green. That's her signal that she can cross. She said that she saw that light turn green, and she went to step off the step like she would any other time that she's walking by herself in downtown Chattanooga. She missed the curb, and she injured her foot. That was the testimony. And again, that gets to the root of our argument, and that is nothing Carta did or did not do made this incident any more or less probable. This is something that could have happened given the nature of Ms. Roberts' visual impairment at any point on her route as she is walking up to the Y, whether or not she's let off at the courtesy stop location, at the Mark stop where she was let off a half a block away, or anywhere else. And that's essentially our argument, Your Honors, is that nothing Carta did caused Ms. Roberts' injuries in this case. And that is my argument, and I'd be happy to answer any questions that the court has.
Mr. Wells, you said it's about a half a block. Was anything in the record that actually shows the actual distance, the measurement from one location to the next?
Not that specifically, Your Honor. Not that specifically. But
Thank you.
Thank you.
No more questions. We'll hear from the appellant in rebuttal.
Your Honors, there's no evidence in the record that Ms. Roberts saw the green light. She certainly became aware that the light had changed and started to cross, but I just wanted to correct that. This could have happened anywhere, but it didn't. It happened in the immediate vicinity of where she was put off before she even had a chance to cross the street to get back to where she was going.
To get back to where the courtesy stop would have been from where she left the bus, did she have to cross any streets or just walk back a half a block on the same?
I'm not sure I understand your Honor's question.
Well, she requests to get off the courtesy stop. She gets off the regular stop. The courtesy stop was what, a half block earlier?
It was across the street, yes, Your
That's
Honor.
what I was asking. Would she have had to cross the street to get back to where the courtesy stop was?
She would not have had to cross 6th Street.
Would you have had to cross any street
Yes,
to
Your
get
Honor.
back to
Yes.
the, okay.
On her normal route, away from the courtesy stop, the reason she had that courtesy stop is because it was a straight shot down to where she was going to the YMCA. She would have had to cross several other streets on that route, but it was a straight shot, and she was familiar
Okay, no,
with it.
I'm not making my question clear. From where she was let off, where she got off the bus, to where she would have been if she got off at the courtesy stop, if you were walking from one to the other, would you require that you cross the street?
Yes, Your Honor.
All right, so it wasn't just a block that you could have walked on a sidewalk straight through back to where she...
On the duty, the evidence in this case showed that Ms. Roberts, although some of her initial statements, because she's blind, she may have said them to the wrong person. When she said, is this the signal light? The driver responded, the traffic light is right there. She said, I'm sorry, I don't see. There's no dispute in the record that Mr. Smith, the bus driver, heard that statement, and there was, quote, no doubt that Ms. Roberts was visually impaired at that time, and yet they let her off the bus.
He heard what statement? Did he actually hear the statement making the request for the courtesy stop, or that this is 6th Street right here?
No, the record shows he did not hear her initial requests for the courtesy stop, but he did hear her confused questions about whether this is the light, whether this is the intersection, and then her statement, "I'm sorry, I don't see." I do quickly want to distinguish the Gatlinburg case, not binding on this court, but also none of the plaintiffs in that case were blind. That is the most significant fact. And the court noted in that case that the area where the plaintiff fell in that case was, quote, "far removed from the trolley driver's view." That is not the case here. And so for that reason, we think it's distinguishable from the Gatlinburg case. Thank you, Your Honors.
Our thanks to counsel for both sides. We appreciate your argument this morning and your briefs on this. Call the next case, please.
Fred Austin Wortman III versus Eric Shirkey.